going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. All right, I've got two quick Judge Simpson clips for you. The first one from the thumbnail, it's a little short, so I threw a little bonus one at the end. But everyone loves a good Mr. Allen, except for maybe the defendant. But we get a Mr. Allen in the first one. All right, before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Courthouse case people versus Philip Zwa.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Zwa. Can you state your name for the record, sir?
Yes,
Can you state your name, please?
Philip Zwa.
Your Honor, we'd be asking to set the matter for preliminary examination.
All discovery is complete.
To my knowledge, it is.
People would have their witnesses available the 22nd.
Just one moment, please, Your Honor.
Yeah.
Your Honor, is the court receipt of the violation?
I am.
Sorry, would the court mind if we could address that first before we set the exam date? We could potentially do the 22nd, but I'm extremely concerned. As recently as October 3rd, was testing positive for fentanyl and opiates.
You had that?
It's my understanding that those positive tests did exist. My client has provided with us a letter from Sacred Heart. He gets scheduled for intake there at October 14th. So while it looks like he may have had a relapse, he is taking the appropriate measures for his recovery.
Yeah, may I make a statement?
You may.
I don't want you to unless you tell me what you're going to say first.
I was taking something with
Mr. Allen.
And Your Honor, the concern of the people is, of course, the most recent positive test being a week ago today, but also that the defendant has never tested negative. Every single test he's supposed to submit it to community correction has either been missed or positive.
I'll just take it. No.
As my client reports, it was not his intent to be taking fentanyl. He didn't know that was in the substance that he had used. He does understand that he has
What was he intending on using?
oxy pills, Your Honor.
I
I don't want you to say it because if you say it, it's an admission. If I say it, it's not.
Well, I didn't know about all that. Anyway.
Ooh, did you hear that slip by the attorney real quick? I don't want to rewind it, but you might want to. When Judge Simpson asked, what did he intend on taking? And he said, oxy, and he stopped real quick and said, pills, Your Honor. Oh. Good thing he caught himself, but it might be a little late.
Anything else?
Judge, only, like I said, he has the intake scheduled for the 14th, so he is taking the appropriate steps to manage that. I would ask the court to allow him to go to treatment and stay out of custody.
Still one except for exam.
I do, Your Honor. And he does indicate to me that Bright Recovery would take him today. He just doesn't, but he has, I don't have any paperwork to that effect, but that's just what he's reporting. They wouldn't. Okay.
Your Honor, unfortunately, I'm sure the court has this on the community corrections report on the second page indicating that the defendant said that he had a tree fall on him. He wanted to get into inpatient on 10-2. It's sort of like lots of information provided community corrections about plans. And now there's another plan for the 14th, and I understand that is his hope. But the concern of the people is whether or not he's going to make it to the 14th, frankly.
Preliminary examination will be set the 22nd, 2024 at 9 a.m. That is before Judge Fresh Hour. This time defendant's bond because of the positive test and community corrections violation. His bond is hereby ordered revoked. Defendant demanding.
All right, like I said, that was a quick one. So I have a bonus Judge Simpson. They're both Judge Simpson clips. But yeah, I understand the worry from the prosecutor. That wasn't a Mr. Allen out of anger. That was a Mr. Allen because they're worried about the guy. And that's fair. Addictions are dangerous. Pill addictions are scary. So hopefully he gets the help he needs. All right, next one.
Court does call the case of the people versus Marco Aris Vankowski.
Absalom, for the people.
Good morning, Your Honor. Robert Elman with and on behalf of Mr. Arizikowski.
All right, good morning.
Good morning, Your Honor.
Good morning, sir.
Marco
Your name?
Vankowski.
All right, thank you. All right.
Your Honor, we're here for a show cause on a bond violation revolving around tether issue, and I do believe at this time Mr. Arizikowski would admit to that violation.
All right, what's he admitting that he did?
Removing the tether, Your Honor. But I would point out in terms of his actions after that removal, when he was called by the tether company to come back in, he went in immediately. He also contacted me. He turned himself in on the warrant when you did issue the warrant. And so I don't think there was any malicious intent here. I think the way he has explained it to me, he was, I don't know if this is the right word I'm going to use here, but fidgeting or playing with the tether, and unfortunately curiosity got the better of him.
Okay. Accept the admission to the violation. All right. What are we?
This has a sense.
Pardon? November 4th. All right.
Remember, as the court, I'm sure recalls, this is a case where the defendant had filed an appeal to the circuit court, and a lot of the paperwork seemed potentially unclear as to how that was received.
And Your Honor, I will say for the record that Mr. Arizikowski, he did email the circuit court an updated, corrected version of the appeal, I believe. And if he's released today, he will go down there and check with them and make sure that he has done everything correctly to follow through with that appeal.
So, but has he received a response back from the circuit court?
I couldn't say, Your Honor. I think he's been in custody since he sent in the email and then turned himself in. So I don't know if he's even been in a place to check for a response back from the circuit court. And he's just informed me that as far as he knows, he has not received a response.
Well, part of my problem is that he was released on a tether. And now you're asking me to release and then interferes with that tether. And now you're asking me to release him again.
Yes, Your Honor. And as I already stated, I don't believe there was any malicious intent with his removal of the tether. And he did. I guess, in my experience, if he was planning or intending to abscond, he would have done so instead of going back to community corrections and then also turning himself in on the warrant. And so, yes, he removed the tether, but his actions aren't those of an individual that we normally see once they remove their tether. And so that's why I'm asking you to give him a second chance on that tether.
I get what you're asking. How do I ensure that this defendant's going to conduct himself, though? I mean, appropriately.
Your Honor, again, I think a tether is a good option.
All right, so you see the dilemma here by Judge Simpson. The guy was released on a tether pending appeal, took his tether off, or he did. I don't. Did they say he took it off, or he was just playing with it and maybe turned it off on accident? That's what he's claiming. He said he turned himself in right after, which might be true. That's what he's admitting to, and I mean, good on him if that's what he did. It's like, oh man, I messed up my tether. But here's the thing: the tethers can be finicky. They're supposed to be there on your ankle for a reason. You're playing with it and it shuts off, and you don't. I mean, did he go right away? Was this at like 8 p.m. and he had essentially a free night before he turned himself in? There's a big. These are questions I would be asking if I were the judge, but he did turn himself in, and now they're asking for another release on another tether after he violated. Judge is usually soft on people turning themselves in, but yeah, how do you release him on a tether after you have a violation of a tether? He's in a hard spot. What would you guys do? Would you give him another chance, or just say, sorry, man, you're in till you know what's going on? All right. Anyways, I'm gonna let this video play out. Thank you guys so much for watching. If you haven't done it already, please hit that like button. And until next time, bye.
Well, I'm going to have to think about that because I don't know a way in which to safely release this defendant given what he's done. And so I'll sentence on the violation November 4th, 2024 at 1 p.m., which is current sentencing is set for. But he's... Yeah, and at this point, I'm just going to have his bond is going to be continued denied.
Okay, and
I will think about it and figure out what we can possibly.
And Your Honor, just for clarity, I do believe that with that being your order, I don't know how much progress he could make on communications with the circuit court pending his pertaining to his appeal, because he is pro se in that. So I just want to let you know I don't know where we'll be with that on the 4th.
Yeah, I don't know either.
Okay.
That is probably a secondary concern for the court. The more pressing concern is community safety, quite frankly, given what's happened. All right.
Fair enough, Your Honor. Thank you very much.
Thank you.